Let me tell them to take their risk.
I'm sorry, what
did you do yesterday?
I had it on
Your Honor,
Hold on, we need to get on the record
oh,
and we can do what we need to do.
okay. I was just gonna say our screen.
Okay, let's get on the record in State versus Thomas. It is Wednesday, just after lunch, when we were supposed to get started, or just after noon. I don't know if people have had lunch. And we are set to resume the trial. We had Ricardo Thomas on the stand. Before we fired up the Zoom session, Mr. Weintraub shared with me that the state had made a new offer for Mr. Thomas. He asked for time to meet with his client to speak in confidence about the state's offer, and I'm ready to get an update.
Ms. Brandt, first of all, I thank the state for the offer. They've been extremely professional throughout this proceeding, last couple of years. And they've extended an offer to us. We've accepted the offer. Would you like to know what the offer is at this time?
I would, but if we're going to go forward with a plea colloquy,
yes.
You can tell me up front, but then we'll just shift to that since we have a jury waiting. I'd want to move expeditiously with the plea so we can let the jury do what it needs to do.
Mr. Hawkins, you want to repeat the offer, please?
Your Honor, I've spoken with Ashley Brown's father about the forecast of this trial and how he's been, and he expressed to me a desire that if we could resolve this with the plea, that would be in his best interest for his home and his family life. And the plea offer is 20 years to serve 10 years in custody. That 10 years commuted to time Mr. Tyler Thomas has already served, which is maybe a month or two over 9 years now, to a reduced charge of voluntary manslaughter.
Okay. And I think we should be clear on the record that Mr. Brown, Ashley Brown's father, actually was able to watch a lot of the trial yesterday in person. He testified, certainly, and then he remained in court. And so he was able to observe firsthand a lot of the discussion and what that meant about his family and that situation. So I can understand why he would have wanted to engage with you on that. I don't want to upset any apple cart. I tend not to sentence where something is commuted to time served. I actually can't commute. The governor can, but it would be reduced to time served. I tend to sentence to an amount of time that was served. And so if it's going to have the state be upset, if I accept the plea, and we're well past final plea, but if I accept the plea, it would more likely be to serve 9 years if he's done more than 9. And then he's done that much time, and that would end his period of incarceration on these charges. That ought not to upset the defense at all. It just would be structured a little differently than you forecast it. But these are delicate negotiations. I didn't want anyone to be surprised. That's not me saying that what happened is any less or more serious, but I'm not a big fan of reduced time served sentences. Why sentence them to more than they've served if the state is saying they don't need to serve anymore on this set of charges? That's a philosophical approach rather than a nomenclature approach.
And from the state's perspective, it's more nomenclature, so we are fine to structure it as a 20 cert 9.
Absolutely, our position, Your Honor. It accomplishes the same end result.
It does.
Yes, sir.
Okay. Then my thought is, given the degree to which this case has been litigated, it would be wise to have written, but we took it off. I've got a form. You get it, Mr. Coutts. The one on the top there is a plea of guilty form that lists all the rights that Mr. Thomas would be given up if he enters a plea. I'll let you all in the comfort of that table go through it, but I would want that executed before we do the plea.
Absolutely.
So why don't you all do that? We'll let the jurors know we're in the middle of something. Once that's complete, we can move forward with the plea. No, all you need to tell them is we're working through something and I'll get to them soon. Thank you. All right, if we're doing this, Mr. Thomas, you and one of your lawyers should come up to the podium. And Mr. Hawkins, are you going to be over here by the witness stand?
Yes.
Okay. If you'll move the camera a little bit, just that way, Ms. Rivers will be able to see you as well while you're talking. Okay, we're back on the record in State versus Thomas, based on Mr. Weintraub's representation and the state's confirmation of that. There has been a plea offer made and accepted. Mr. Thomas has completed a written plea of guilty form, which he acknowledges the rights he will be waiving in exchange for the plea. In just a moment, Mr. Thomas, Mr. Hawkins is going to put you under oath. Once you're under oath, you'll need to answer his questions and mine truthfully and completely. If you have any questions of your own, you need to let Ms. Brandenburg or me know. Will you do that?
Yes, sir.
Okay. When you're ready, Mr. Hawkins.
Mr. Thomas, would you please raise your right hand the best you can? You solemnly swear or affirm the testimony you're to provide shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Please state your true, correct legal name.
You can put your hand down.
Jarrell Thomas.
Are you the same Tyler Jarrell Thomas in indictment number 14 SC 124579?
So you need to let him finish the question before you answer.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Nah.
Is there a medication that you normally take that you've not been given today?
No.
How old are you, sir?
36 years old.
What's the highest level of education that you have
I
completed?
attended college, University of West Georgia.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you're charged in this indictment with malice murder, felony murder, aggravated assault, and possession of a firearm during the commission of a felony?
Yes.
Do you understand that you have the right to plead not guilty to these charges?
Yes.
Do you understand that if you pleaded not guilty or remained silent, you would receive a public jury trial?
Yes.
Have you reviewed the waiver of rights form with your attorney?
Yes.
Did you sign that waiver of rights form indicating you understood all the rights that you're giving up by entering this plea today?
Yes.
Have you had enough time to speak with your counsel about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss the case with your attorneys?
No.
Are you satisfied with their services?
Yes.
Ms. Brandenburg, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
So waived.
Mr. Thomas, do you understand that the minimum charge to which you are pleading guilty to, count 1, malice murder reduced to voluntary manslaughter, is a 1-year sentence and the maximum is 20 years to serve in prison?
Yes.
Do you understand that neither the court nor attorney's office has anything to do with parole, the Department of Corrections, or the Board of Pardons and Paroles, and no one can guarantee you parole should the judge sentence you to time above what the state and defense are requesting?
Yes.
Do you understand that we are past the final plea stage? So this is a blind plea, and that there is a joint recommendation between the state and your attorneys of a total sentence of 20 years, the first 9 years to be served in custody and the balance on probation?
Yes.
You understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended, up to the maximum sentence on this count?
Yes.
And do you understand that once you enter this plea, you do not have a right to withdraw that plea?
Yes.
You understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
You understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
You understand that if you are placed on probation of any kind, and if you violate any criminal laws of any governmental unit or violate any special conditions of probation, you may be subject to the revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess nor use a firearm as a result of this conviction?
Yes.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences because of this guilty plea, just as there would be from a conviction following a trial?
Yes.
And do you understand more specifically that your plea may affect your right to vote, right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today?
Yes.
Now, Mr. Thomas, you're giving up a number of constitutional rights by entering this guilty plea, and the court needs to make sure you understand each right you are giving up. Do you understand that by pleading guilty, you're giving up the right to a speedy and public trial by jury?
Yes.
You understand that by pleading guilty, you're giving up the right to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you're giving up the right to confront and cross-examine witnesses called to testify against you?
Yes.
Do you understand that by pleading guilty, you're giving up the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case?
Yes.
Do you understand that by pleading guilty, you're giving up the right to the presumption of innocence?
Yes.
Do you understand that by pleading guilty, you are giving up the right to testify on your own behalf or to present other evidence if you wish?
Yes.
Do you understand that by pleading guilty, you're giving up the right to subpoena witnesses and compel the production of evidence?
Yes.
Do you understand that by pleading guilty, you're giving up the right to have the charges against you proved by the state beyond a reasonable doubt?
Yes.
Do you understand that by pleading guilty, you're giving up the right to appeal if convicted of these charges after a trial?
Yes.
And you understand that we are actually in the middle of a trial, Mr. Thomas, right?
Yes.
And by entering this guilty plea, you are giving up the right to continue with this trial and have the jury that has been selected make these decisions. You understand that?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes.
And are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
Mr. Thomas, how do you plead to the charge in count 1, murder reduced to voluntary manslaughter?
Guilty.
Are you entering this guilty plea freely and voluntarily with full knowledge of the charges against you?
Yes.
You understand that you may have only a limited right to appeal this guilty plea?
Yes.
You understand that your trial attorneys are required to represent you unless another attorney is substituted in their place?
Yes.
Do you understand that unless counsel is substituted or permitted to withdraw, they will represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
Yes.
Do you understand that you have only 4 years from today's date to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Do you understand that you have 30 days from today's date to file a notice of appeal in your case?
Yes.
You understand that you have until the last day of the current term of court to file a motion to withdraw your plea?
Yes.
And you understand that any of these filings we just discussed must be filed by your counsel unless you are authorized to represent yourself?
Yeah.
Your Honor, the facts of this case are that on June 22nd, 2013, Mr. Ashley Brown wrecked his vehicle into a home at 3255 Kingston Road. Police responded to that scene. They found he had been shot numerous times in his back. Medical examiner determined that these gunshot wounds caused his death. Police located numerous .32 caliber shell casings within the backseat area of that vehicle. They also located a secondary crime scene at 103 Dogwood Drive. That 103 Dogwood Drive address is within Fulton County, Georgia. Police located broken glass that was similar to broken glass on Mr. Brown's vehicle at that 103 Dogwood Drive address. They also located additional spent shell casings. Police were able to determine the last person Mr. Brown was in communication with was Ricardo Thomas, based on the text messages within Mr. Brown's phone. Detective Thorpe reached out to Ricardo Thomas. Initially, Ricardo Thomas indicated that he was with Ashley Brown, that they had just completed a drug transaction, and that they were at the Dogwood Drive address smoking marijuana when two unknown men approached them and opened fire. Detective Thorpe attempted to secure an in-person interview with Ricardo Thomas. Ricardo Thomas failed to appear for that interview. Detective Thorpe then obtained or communicated to his probation officer that Ricardo Thomas had admitted to participating in a drug deal while on probation. After communicating that, Ricardo Thomas's probation officer secured arrest warrants for Ricardo Thomas. A subsequent interview was scheduled between Detective Thorpe and Ricardo Thomas. Also present at that interview was Ricardo's attorney, Sam Rail. There is no known recording of what was spoken at that interview. There was brief notes within Detective Thorpe's report indicating that Ricardo knew who the shooter was in this case. A few days later, the three parties met again for a formal interview, that being Detective Thorpe, Ricardo Thomas, and Sam Rail. At that time, Ricardo Thomas indicated that he was working to secure a drug deal between Ashley Brown and Tyler Thomas, that Ricardo was serving as the middleman for that drug transaction, and that Tyler was supposed to supply the cocaine. Ricardo Thomas told Detective Thorpe that when the parties met together at the Dogwood Drive address, that Tyler Thomas got into the backseat of the vehicle, produced a handgun, and initiated an armed robbery on Ashley Brown. Ricardo Thomas stated he immediately fled from the vehicle and heard gunfire, and then saw both Ashley Brown and Tyler Thomas leaving the location in two separate vehicles. Ricardo, when asked directly, was there anybody else with Tyler, Ricardo did say no. There was nobody else, or he didn't see anybody else with Tyler. Ricardo was subsequently indicted along with Tyler Thomas for these offenses. Ricardo was able to present a proffer statement through his attorney at the time to my office back in 2015. In that statement, he indicated much of the same as what he indicated to Detective Thorpe. However, he added that he did see an individual whom he only knew it by the nickname Turtle, also with Tyler Thomas, and also saw that individual get out of the car and heard more gunfire after seeing Turtle get out of Tyler's car. Ricardo also explained that Tyler had told Ricardo that Ashley and Tyler had wrecked shortly after the shooting, and that Tyler instructed his girlfriend Jaleesa to make a false report of a hit and run, and that Tyler was driving Jaleesa's vehicle at the time. Tyler Thomas did go to trial in 2017. Ricardo testified at that trial consistent with this proffer statement, and Tyler was convicted. There was an appeal, or a motion for new trial, which was granted. Your Honor, we came to trial today to retry Mr. Thomas with much of the same evidence. There was some additional evidence of cell site location information. There was cell phone records that did corroborate Ricardo to the extent that he was in communication with Tyler, and that Tyler's cell phone did move towards the area of the crime scene and then away from the area of the crime scene. However, yesterday afternoon, as Ricardo was testifying, there were some things that he was inconsistent about from his last trial testimony. Now, he was still on the stand at the time this plea deal was reached, so I don't know how he would have responded to that, if he would have said he was nervous or forgot, but nevertheless, there were some things that were inconsistent about his testimony yesterday afternoon. I was able to speak with Mr. Brown, Ashley Brown's father, who testified first in this trial and has been sitting in the courtroom since. And I explained to Mr. Brown some of these factors. And I point blank asked Mr. Brown, what would you like to see? Ultimately, it's my office's decision, but Mr. Brown expressed a desire to resolve this case with a plea if he could. This incident has obviously been a living nightmare for Mr. Brown for the last 11 years, and he wants to bring it to a close. So that was a major factor in the state's decision, along with Ricardo's testimony yesterday, but a major factor in the state's decision of conveying this plea offer. He did wish to address the court at the appropriate time. I know my factual basis was more than necessary for the plea itself, but I think it also presents why the state has adjusted its offer from Monday.
Ms. Glenn's testimony at the first trial was what?
Ms. Glenn testified that at the time Tyler had her vehicle, that the night of the murder, that Tyler returned her vehicle, that when Tyler returned it, it had been damaged, and that Tyler told her that a motorcycle had struck the vehicle and to file a false hit and run report. Ms. Glenn has since recanted that testimony, claimed it was not truthful, and provided a reason that she said so. The state does not believe her version now, but she has fully recanted that prior testimony. At the time that she did testify, she was had a pending felony shoplifting, which formed the basis for the prior court granting a new trial.
Melvin Thomas, known as JR? Is that what people call him, JR? Based on your interactions with him preparing for this trial, would he have corroborated what Ricardo Thomas said about the sort of comings and goings leading up to, I know he wasn't present for the failed drug transaction and Mr. Brown's murder, but he was pretty heavily plugged in earlier in the day. Was he going to confirm that, not remember it, or contradict that?
He was going to confirm these aspects of it. He testified at the previous trial. He was going to confirm that he and Ricardo did travel to Atlanta for a car show, that they missed the car show, that they went to get something to eat, that they went to an apartment complex where they saw Tyler, that Ricardo and Tyler spoke to one another, and that Melvin drove Ricardo to a McDonald's where Ricardo then met up with Ashley Brown. However, in speaking with Melvin this morning, and I did convey this to defense counsel, he told me that he saw Tyler driving a green Mercury vehicle that afternoon. The last time he testified, he said he did not know what kind of vehicle Tyler was driving, but he has changed his statement and now stating that he saw Tyler driving a green Mercury. That is inconsistent with Jaleesa Glenn's vehicle, which was a red Nissan Altima. In learning that information, I did convey that to defense counsel. Other than that fact, which I think was a significant factor in the state's decision, Melvin Thomas's testimony would have remained consistent with this trial testimony.
And the cell site information that Detective Leon Packer would be able to discuss at this trial that he was precluded from doing in the first trial, you sort of glossed over that. And I appreciate it's not to the degree of accuracy of geofencing, where you could say within 20 feet of the scene of the shooting was Tyler Thomas's phone, but how closely does the cell site data, as Leon Packer would be able to present it, track the route Tyler Thomas would have taken if he was at 103 Dogwood at the time of the killing?
What it showed is that Tyler was,
or his phone, that his phone was.
What it showed is that Tyler's phone was in one part of Atlanta. Ricardo's phone was in another. Both phones moved to the area of Dogwood Drive. At the time of the homicide, they were connecting with the same cell site or same cell towers using the same sector.
They were close enough together that they were hitting off the same sector of the same cell tower.
Yes, Judge.
Okay.
And then both phones moved away from that location.
Okay.
There was yes, Judge.
Okay. Thank you. Because this was an unanticipated development, I don't have anyone from pretrial services or probation here. What can you tell me about Mr. Tyler Thomas's criminal history?
One moment, Judge.
It's a big criminal history.
No, this is the case file. Judge, I can tell you that
I don't think there are any convictions because he wasn't charged with possession of what this was a bunch of years ago.
That's correct, Judge. He did not have any felony convictions. He did have prior arrests. No felony or first offender dispositions, Your Honor.
Okay.
Because of charge.
All right, if you find it, we can talk about that later. I'm very happy to hear from Mr. Brown now, if he still wants to give a victim impact statement. And if Mr. Brown, he's actually going to sit, come on up, Mr. Brown. Mr. Hawkins, Mr. Brown is going to sit where you are so that he can have a microphone and we'll hear from him. Good morning, sir. I guess it's afternoon now. Good afternoon.
Good afternoon, Judge. I get confused myself sometimes.
It's good to see you.
But a broken clock is right at least one time a day. So
there you go.
all right.
It's good to see you 2 days in a row. Tell me what you want to share.
Well, first of all, I hate being here, but under the circumstances, I had to come and represent my family. I'm a disabled veteran. I served in the military for a number of years, 6 years, and I left the military because of post-traumatic stress disorder. But I'm still suffering today. We got a motto in our group that some gave, some gave, some still do, and some gave all. I was fortunate enough not to give all, but I served with a lot of people and went to school with a lot of people that's not here today. But regardless of that, my wife and I, my wife could not be here because we got death in the family. My sister-in-law that stayed with us, my wife is taking care of it. But our concern was there was no remorse given to our family. And regardless of what Ashley did, he still was a human being. And the way he died was a tragedy. But even in death, you have a lot of people that's impacted. It's like war. People don't think about war, but they go to war, but all the damage is done after the war. And the same thing about here. Ashley had 4 beautiful children and a stepchild. Those kids now are going through a lot of emotional stress. To come to a family reunion with your grandmama and you leave it with a dad that you would never see again. And there's a thing that's etched in my mind today. My granddaughter, the only daughter that Ashley had, she sat down and she cried and she told my aunt, my sisters that, listen, I know what I'm about to say is wrong, but she said if I could just see my dad just one more time and never live with me forever. And there was a picture where he took her, he was an avid fisherman. He thought he was the best fisherman in the world. She would have been a good fisherman because he was going to teach her. And one of the first trips that they went out, she caught a fish, and he was so happy about that. But to get back, the reason why I want to make the impact statement is the fact that my wife and I always agreed that we did not want an innocent person to go to jail. But yet still we wanted some accountability. And in the past, nobody ever reached out to us and offered any kind of remorse about I didn't do it or send a card or something like that. And that really hurts, because it's almost like Ashley's life didn't matter. There's nothing we can do to resolve this problem, but I agreed to the deal because of the fact that I'm 77. I'll be 78, my birthday. My wife has medical problems. My psychiatrist had changed my medication so that I can get some sleep. I haven't slept since his death. That was the hardest thing that ever happened to me. And I swore up and down when I left Vietnam, I thought I would leave all my problems behind me. That is the day that Ashley died. That was the worst day of my life. And there's nothing else that would change that, But I agreed to the deal because I'm just going to put some closure to it. If there is such thing as closure, you cannot close anything like that because the memories are there. And the mind has an AIX of its own. It will allow you to think that you're closing something, but it's going to be there. And I know I got to live with it the rest of my life. And you have to live with what happened. So it was in the best interest of me and my family that we go ahead and try to just resolve this. It's not what we wanted, but you don't always get what you want. You get whatever's given to you.
Right.
So with that, I wish him well. I hope this never happens to anybody else. And I hope that his family recoup from this, because just like we suffer, I know his dad suffered. I know his dad worked, I think he worked for Georgia Power Light Company or something like that. I don't know his background, but regardless of background, whether he was an educator, just a common worker, this whole ordeal have taken a toll on the whole family and the court. With that, I'd like to wish him well, and I can't add anything else to that.
We've added plenty, Mr. Brown.
But I want to thank the court, and I want to thank all the supporting people that stood by us. I want to thank the people who represent Ashley, because Ashley's not here to speak for himself. Nobody knows what goes down. I have no animosity because of anybody. I wish, not being selfish, I wish that it worked out the way he wanted, but that's the way life is. I didn't get everything I wanted in life.
Right.
And with that, I'd like to thank the court.
Okay.
Have a blessed day and be safe.
Thank you, Mr. Brown. Same to you. Mr. Hawkins, anything else from the state?
No, Judge. This has always been a case that stemmed primarily from Ricardo Thomas. His credibility has always been central to this case. And he has given several different versions of events, including yesterday. And even after he testified last time, he was able to resolve his case with a very favorable plea deal that I know would have come into evidence. So just taking into consideration everything, that the evidence available to the state in this case, and what transpired yesterday, in speaking with Mr. Brown, I think this is the best path forward.
Okay, thank you. Ms. Brandenburg.
Your Honor, we would ask that the court accept the state's recommendation in this case. We appreciate Mr. Brown's magnanimity in this case and generosity. As Mr. Hawkins described, the evidence in this case hinged on Ricardo's testimony and many statements, and we were preparing a robust cross in defense of that, including dealing with the new cell information that was going to come in, because there is evidence from those records that further impeaches the claims that Ricardo made. But we would ask that the court accept the plea and accept the recommendation. As Mr. Brown stated, Mr. Thomas's family is also here and has been here and supportive of him all the years that Mr. Weintraub and I have represented Mr. Thomas. The family support is remarkable in this case, in my experience. And as the court is aware, we've been here before Your Honor several times, and we've fully litigated the case to get to the point that we're at. But Mr. Thomas feels this is in his best interest, and he would like the court to accept the recommendation.
So in that vein of best interest, the plea form that Mr. Thomas completed and signed, and that you signed as well, Ms. Brandenburg, indicates that it's an offered plea. And I just need the record to be clear, because I have a different set of questions for Mr. Thomas if it's an offered plea as opposed to a guilty plea. His response on the record was, I plead guilty. That doesn't lock him in. If you want on the record for this to be an offered plea, they just don't align. Question was, how do you plead? Answer, guilty. But the guilty plea, and that's what controls, but the guilty plea on the form says, I'm making this decision because I believe it is in my best interest to do so, and there is a factual basis for my plea, parentheses, offered plea. And those are two different things. And so I'm curious to know what the plea is in this case, so that the final disposition form reflects whatever it is that is being tendered by Mr. Thomas.
It is an offered plea, Your Honor.
All right. So, Mr. Thomas, why was your cell phone so close to the site of Mr. Brown's shooting death?
I resided in the area
Where'd you reside?
at 106, apartment 106 in Dogwood.
Yeah, and just a coincidence that right after the shooting, your cell phone was leaving the area?
No coincidence.
Pardon me?
So I don't know. I don't know. I don't even know the events or to know what's what. I don't know.
Because it's been so long, or?
I lived in the area. I don't know if I was coming. I was going back and forth to Atlanta to Carrollton.
How long had you lived at 106 Dogwood?
From 2013 up until my cousin had her baby because I smoked marijuana. So when she had the baby, I moved out of the apartments.
You had been staying with your cousin?
Yeah.
When did you move in? That year, 2013?
I don't know, 2012.
2012? Okay. Anything you want to add?
Oh, sir.
So your version of events is your name just got dragged into this by Ricardo.
Most definitely. I talked to Ricardo. I know Ricardo. And he was on drugs real bad, and he called me. He was asking for money and directions, and I don't know how I got tied into the murder.
What was your line of work back then?
I had got certified with the state. I got my blue card. I was doing celebrity security for some entertainers.
You had some pretty fancy lawyers for that trial. You have some pretty fancy lawyers now. You got paid real well doing celebrity security?
Yeah, got paid well, family, inheritance.
Inheritance. What was the inheritance? I mean, dollar amount, but you had a relative who was in the oil business, or?
Just left me some money. I had family support and finances.
What are you going to do when you eventually get out?
I planned on going to law school if I wasn't a felon. I want to do some outreach program with my celebrity friends and tell them about the system and how you could be caught up in the system. And somebody a lie can cause you a whole bunch of turmoil and affect your life in so many ways.
Who are your celebrity friends?
Everybody that's in Atlanta. I was in the security from the guys that's on trial now to the guy that YFN Lucci, the Carlos Walker, he's dead now.
Yeah.
Jonathan Jones, he plays for the Patriots. Jay Crowder, he's playing Major League. He's playing NBA. Got a lot of friends as celebrities.
Okay. Do you have kids?
2 little girls, 11 and 13, and stepson.
Are they in Carrollton?
Columbus. One is in my 11-year-old is in Houston, and my son is in Douglas County.
All right. Anything else?
No, sir.
All right. Well, Mr. Thomas, I find there's a factual basis for your plea, in that your plea is knowing and voluntary. Knowing means you've understood all the things that we've been discussing concerning your rights as a criminal defendant. The fact that you're waiving or giving up many of those rights to enter a guilty plea. Do you feel like your plea is knowing?
Yes.
No questions about anything anyone said so far? Okay. And voluntary simply means that no one's forcing you to go forward. You've had, with the plea, you've had a chance to discuss with both your lawyers and others your decision to go forward with this offered plea. Is that a fair statement?
Yes, sir.
All right, then I will accept your plea. I'm sentencing you to the Probation Options Management Act. That means that while you're on probation, which you will be for a while, if you have a minor issue with probation, and that would be along the lines of you miss a meeting or something, you and probation will sort through that. But if it's more significant, typically you get arrested for something, that comes back to me, and we will work through what the consequences are of that. I will accept this as an offered plea based on what you and your lawyer have shared with me. I wish more of a chapter was closing for Mr. Brown and his family, but this is where we are. I may have missed it, Mr. Hawkins, but you didn't talk about your view as to what merges or what is vacated given the reduction of count 1 to voluntary manslaughter. So if I missed it, I need you to repeat it. And maybe you're null processing everything else.
Yes, Judge, the state is moving to null process the remaining counts.
Okay. So we're going forward with count one, which has been reduced to voluntary manslaughter. On that count, Mr. Thomas, I'm sentencing you to 20 years to serve 10 with the balance probated. You'll get credit for all the time you've served. You have an open case in front of me for which you have no bond. You'll need to work through that, and we'll figure out what's going to happen with that when we get you in court soon for that. It will be a special condition of your probation that you have no contact, direct or indirect, with the Brown family. And I understand there's some interconnectedness, at least there was through Ricardo. Since you two are cousins, there may be the Brown side of that family is closed off to you while you're on probation. And unless and until I get documentation that you have a verifiable job inside 285, it will be a condition of your probation that you stay outside the perimeter 285. Anything else, Mr. Hawkins?
The state would like a no contact provision also between Tyler and Ricardo.
That would be a good idea. No contact with Ricardo Thomas. But, I want to be thoughtful about that because Tyler Thomas may be going to a family event and Ricardo being there. I guess the family needs to navigate that as to how they're going to do that.
I know that
and there may be some clear lines that have been drawn since things happened.
There's been a major fracture in the family as
Okay.
a result of this, but up until the last trial, since the last trial, since Ricardo did testify, Mr. Tyler Thomas has been in continuous custody. So the state understands will be released. I don't know when, given the new charges.
Well, soon.
I think that would be appropriate. And if either side wants to later on seek to amend that, I think that would be the appropriate time.
Okay, well, let me get input from counsel for Tyler Thomas, because I don't want to set up, I understand the purpose of that condition, but I don't want to set up a scenario where Tyler Thomas can't be at an event that his kids are going to, or this or that. It's complicated, but help me think through that.
Your Honor, can you just add the word no violent contact? We've had that in almost every bond order that we have over the years. That would allow them to have a family function where he would not be in violation of any conditions. And then we can maybe come back, Ms. Brandenburg and I, we can modify things. But at this time, if we can put in no violent contact, I think that may, assuming there may be a point when we get out on the other matter.
Sure. I'm open to that. The concern is that there could be text, social media, this or that, and it's hard to say words are violent, but there could be words that are expressed to Ricardo that put him in a state of unease. And how about this? There will be the only contact, I'll figure out how to word this correctly, but the only contact with Ricardo Thomas would be at a family event. They can be at that same family event. And then that needs to be no violent contact. But if it's violent, that'd be a violation of the law anyway. But otherwise, you're not calling them, you're not texting them, anything like that. But I don't want Tyler Thomas to be prohibited from going to a family event because Ricardo or his part of the family is there as well. It sounds like that might not arise so much given the fracture that you mentioned. But when Mr. Thomas is out and Tyler Thomas is out and wants to rebuild and move forward in whatever way, law school, if he gets things expunged, or corporate security or other things, I want him to be able to reconnect with family. And in case there's ill will flowing in both directions, Ricardo ought not to be able to say, haha, you can't do this because I'm going to be there at that. I don't attribute that to Ricardo, but families are complicated, especially extended families. So the way I'll word it, and I'll be open to rewording it if it is unduly restrictive, is that Tyler Thomas is to have no contact with Ricardo Thomas outside of family functions, at which time it would be no violent contact. And I think that would do it. That would allow family events, but no text, social media, anything like that. And that's how we'll work it. Anything else from the state?
No, Your Honor.
Ms. Brandenburg, anything
Honor.
else from Tyler Thomas's side?
No, Your Honor.
Okay. Then Tyler Thomas, I will see you soon when we start moving your other case forward. Are you two, either of you on that case, or you were retained for this case only?
Yes, Your Honor.
Okay. So Mr. Thomas, when I see you next, it'll be for the arraignment on that case, just to get it rolling. There's already a prosecutor assigned. You should be working through family channels or whatnot, how your representation is going to work. You're absolutely entitled to appointed counsel, but you've managed through whatever means to always have retained counsel. And that case will move faster if a lawyer is filing an entry of appearance sooner rather than later. I put that case on hold because this trial was happening and I didn't know how it was going to play out. And at one point there was even an offer to resolve both together. And then these lawyers would have graciously stood in for purposes of taking the plea in that case. But it sounds like you've retained them to resolve this case, which they've done at a pretty steep discount for you. Just be thinking about that and consult with your family. So when I do have you come back for the arraignment in the other case, we can get that going. Do you have any questions for me? Okay. Thank you, everyone.
Thank you, Judge.
Mr. Hawkins and Ms. Hodge, I know they're there. Mr. Hawkins and Ms. Hodge, thank you for your work on this case. It was an inheritance and was a little bit from the state side, an ugly stepchild case wandering around. And I appreciate you both embracing it and being ready to move forward and being realistic about how it was going. Mr. Weintraub and Ms. Brandenburg, it was nice working with you as well. I've had to deal with Weintraub before. It was my first with you. You take the edge off it. Thank you for being here. I'm going to release the jurors. I'm going to go talk with them. There may be some who have questions for you all. If you want to stay, can I write them down? That's right. I'll get them on note cards. But I will offer up the opportunity for them to come to the jury box if they want to engage with you all. You don't need to stay. We didn't get very deep into the trial anyway. But some lawyers are always interested in hearing what jurors have to say. I don't know if they even formed an opinion about their thoughts about the way the case was going. But I'll ask them that anyway, because sometimes it's helpful for them to say, hey, here's what was on my mind. We just didn't spend a lot of time with them. So if you choose to stick around, let one of the deputies know, and I'll connect you if they want to stick around. I will get the final disposition entered today, and that will close this case out. And then Ms. Nix is the prosecutor who will pick up the other case. So anything else from the state? Enjoy the rest of your week. Anything else from the defense?
No, Your Honor.
All right. Thank you, everyone.
Marty, can you help me?
Well, we can put it on my